I think is going to interest most of you. As in the past, what we've done is we asked our attorneys to kind of give us the top 5 questions they're usually asked. And I think by the time we cover those questions, most of your questions may have been answered. At the end, if there are any general questions you guys have, by all means, we'll go through and give everybody a shot to ask their questions. So without further ado, I wanted to thank Southway Association for the breakfast this morning. And we'll get started. So we have Holly Thomas here. Holly's been here a few times before. Holly's going to talk about the commercial ARR contracts, which is a favorite of mine. So I'm very kind of interested, looking forward to that. We got Blake Slater here. Blake's going to talk about landlord, tenants, and I guess, yeah, evictions. And then Kelly Richardson. Kelly's going to talk about new laws that affect real estate, and specifically, hopefully, you know, some of it will be commercials. So we're going to get started. I'll start with Holly, please. First question: When is the right time to use an AAR contract over a CAR win form?
So good morning, everybody. Just by a show of hands, how many of you have used an AIR form? So not that many of you. It is. It's absolutely available for you through your WinForms account with CAR. I think Mo told me it's $149 for the year, and you can get access to not the whole library of AIR forms, but enough for whatever you're doing. It's a product that's different from the CAR forms. It is. I mean, one of the things Mo was commenting about is you can actually redline things out of it, which is interesting. The reason why CAR doesn't allow you to do that is because you don't have a law license, most of you, so they don't want you to be practicing law, so that's why CAR doesn't give you the opportunity to do the crossouts and the insertions on your CAR forms. AIR, on the other hand, thinks go for it. So they will let you do the red lines, but I wouldn't recommend you getting creative about that. Really, what you would want to do is just cross out the things that aren't applicable, because that particular contingency isn't applicable to whatever the transaction is, or it's all cash, so you don't need the financing portion. But I really wouldn't recommend that you start doing a lot of insertions and crossouts, because again, then you're practicing law without a law license, and that's really frowned upon. So the AIR form, what I really like about it is that very pro-seller. If you're using the purchase agreement, it is a passive removal of contingencies as opposed to an active removal of contingencies. So CAR, you have to, in order to remove your contingencies, you actually have to write down, I hereby remove my contingency. But AIR doesn't work that way. AIR says, if you don't object to me and tell me that you don't like these problems by whatever the day period is, then you agree that everything's fine. So it passively goes away unless you object. And so from a seller's perspective, or even a landlord's perspective, that's great, because then you don't have to do anything, right? You just bide your time, and eventually the deal is going to keep moving forward. So that's a really pro thing for this. It's also a really good form for something that's a little bit more complicated. CAR forms, the purchase agreements are basically all the same. While they have different names to them, the purchase agreements paragraphs are different numbered, but they're essentially the same form. And AIR is set up for something that might be a little bit more complicated. Not owner-occupied, larger transactions. It gets a lot more specific about the kind of due diligence that's going to be provided. It is for retail, industrial, you know, really your real commercial transactions as opposed to just multi-unit. And of course, if your seller is not owner-occupying, you don't have to do leasebacks or any of that. So CAR is the form really to use if you're going to have those kind of issues involved. So,
thank you, Holly. So back to Blake. So let's talk about if a landlord or tenant is a LLC, LLP corporation, and as an entity. And is an attorney required to initiate or defend an eviction? And then follow up with that, what happens if the business status is suspended, so if they don't exist?
Yeah, and so if we're dealing with evictions, one of the things we want to know about is what type of entity is bringing the action, right? Whether it's an LLC or a corporation. Can you guys do it on your own, or does an attorney have to be involved? Anybody have a thought? By common law, attorneys have to represent you. All right, so you got to get somebody to step in. So another consideration, if the owner or tenant is an LLC or a corporation, you're going to have to get an attorney involved to do it, to defend or initiate an eviction. And you might want to know, why is that? There's a couple reasons why. Holly was mentioning one of the big ones. We don't want people engaging in the unauthorized practice of law, right? Eviction is a lawsuit, so that's one of the reasons why you should be represented. Another one that's in the case law, it's developed by case law, which is kind of interesting, is that they want to make sure that there are qualified professionals that are appearing before the courts. Holly's laughing because while there are, you know, good and bad realtors, there's also good and bad attorneys. So it seems kind of, that's kind of serving our own purpose as attorneys. But I think the big one, the big rationale why, is you want to make sure you're separating. Oh, is that? Sorry. Is that better? I don't know if that's any better. One of the big reasons why is you want to make sure you're separating out the people that run the LLC or the corporation as shareholders and officers defending themselves. So if you have this entity to protect you, to say that it's a separate body and not yourself, you want to make sure you're not also going into court to defend yourself, to defend your company, or to initiate the eviction. Now, to the question of what the status is on the Secretary of State's website, right? If you do have a business entity, you want to make sure that it reads active on the Secretary of State's website. Certain things you got to do. You got to make sure you're doing your statement of information filings. You're paying Uncle Sam. What happens if you don't? It's a real problem, whether you're a landlord or a tenant. If you have this business entity that you want to appear in court, if you're not active, if you're suspended, right? If there's a reason why on the Secretary of State's website that you're suspended, what else is suspended? Your rights and privileges as a business. So how can that play out? It could be that you're taking you're an LLC, you're taking a tenant to court, but if they bring up to the judge that you're not currently active, you haven't paid your dues, they can get it rejected. They could pull that entire lawsuit out of there. Same thing with the tenant, right? If you're having issues with the landlord and you're complaining about they're not providing water, or they're not fixing what they're supposed to, so I'm not going to pay rent, and they take you to court and you're not active on the Secretary of State's website, you're not allowed to defend yourself in the eviction. So it can be a real problem if you're going to be having that benefit of separating yourself away from it because you're a business entity. You want to make sure that you remain active on the Secretary of State's website so you can enjoy the whole reason why you did it.
Thank you, Blake. So, Kelly, let's talk about fair housing and state and federal regulations regarding sexual harassment. Let's talk about that for a couple minutes.
One of the questions that I'm not getting asked enough is what's going on with the fair housing laws in California. They have changed dramatically across the United States as of October 2016. And if you're dealing with rental properties, the management of rental properties, the ownership of rental properties, it's probably the best kept secret in the United States real estate law. And that's that since October 2016, HUD adopted regulations that require a housing provider to protect residents against sexual discrimination by way of harassment. Now, you may know from your business experience that sexual harassment is often a very big issue and a legal liability source in employment situations. Well, the sea change in fair housing law is that nationally HUD has said that now we have to take the same standards in the employment context and apply them to the housing context. So whether, I realize this is a commercial forum, but this is bedeviling property managers and asset owners not only in commercial residential properties, but also in what we call homeowner associations, because they're also considered housing providers. So here's what the regulation has said since, October of 2016. That the housing provider, in the definition, includes not only the owner, but it includes the manager. So the owner and the manager can be disciplined or sued for violating the fair housing laws in this way. And what are you, the housing provider, supposed to do? You're supposed to prevent and respond reasonably to unwanted sexual advances in your housing project. And you're also supposed to prevent hostile environment. Not hostile in people being mean and irritating to each other, but a sexually hostile environment. Now, in the workplace, we know that an unwanted sexual advance is something that we as employers have to respond reasonably to. And what is reasonable depends upon the circumstance. But now let's talk about your investment group has a management company or an on-site manager in place, and Joe comes to the manager and says, hey, I was walking down the hall the other day, and Larry made a crude remark to me of a sexual nature, and I feel bad about it, and I want to know what you're going to do. So your reaction to that 2 years ago could have been, come on, you're a big boy, handle yourself. You know, if you have a problem with another tenant, deal with it, right? And that's where we would have probably all left it. Well, if you do that now, you have just set yourself up for a clear violation of federal regulations and a lawsuit potentially. Because if you didn't know it, there's a nice little group of attorneys out there that love filing fair housing lawsuits against housing providers. So now they have a whole new thing to push. That is that if you don't respond reasonably, you've not only violated the law, but you have opened up a path of liability to yourself. So what you're expected to do now is to first investigate the complaint. So you're going to go to Larry and go, Larry, Joe says that, and right away you see the problem right immediately, okay? So Joe says, okay, that you made this unwanted advance, this crude remark. So now you're gonna have to ask Larry, did this happen? Now, if Larry says, yeah, you know what, I was trying to be funny, and or I had a few too many, or I was smoking the marijuana that's now legal, whatever that story is, okay. But more likely, what is Larry going to say? He's going to say, what? He's crazy. I said no such thing. Now what do? We don't know the answer to that question, because what you're supposed to do is what's reasonable. So I guess that means you're supposed to what? Decide who's telling the truth? Joe or Larry? Right? Well, that's what we lawyers are going to be struggling with now for many years to come. In an employment context, it's handled differently, right? Typically what we're going to do is we're going to counsel the employee. We may relocate them. We may tell them, hey, look, you know what? You're having this issue. I'm not saying that you did it, but the safe bet is I'm going to move you to a different desk, and can you steer clear of Larry for a little while, okay? But what do you do with a tenant? You declare them in breach of the lease? How many of you work with tenant leases in your rental properties that say you will not proposition another tenant? Exactly, not a single hand. Now, the fair housing people, the HUD, was asked in the comment period to the proposed regulations in 2016, well, what do we do with this? What if the housing provider has no legal ability to respond to this? And HUD says, and this was asked, by the way, of the homeowners association groups, well, what if the board doesn't have something in their CC&Rs or rules about unwanted sexual advances? And HUD says, well, if there is the ability to do something, then we expect the housing provider to do something. That was the great guidance that we got. So I have the main thing I can tell you right now is that it's going to be a number of years. We're going to have lawsuits happen. Then we're going to learn from those case histories, just like we do in the other aspects of fair housing. And then we're all going to find some paths to comply with that. But for the next few years, it's very perilous ground. I can tell you that the buzzword that's really come on, at least in California, in fair housing generally, is this concept of the interactive process. So if you have a fair housing complaint, whether it's sexual harassment or whether it's discrimination of some type, failure to accommodate a claimed disability, of course, is what we mostly deal with, right? How you respond and the interaction you have with the allegedly offended or complaining party is going to be really critical to what the enforcement people and potentially what a judge does, that interactive process. Now, there's another half to this sexual discrimination stuff, and you heard me say hostile environment. Well, now, in the workplace, a hostile environment means a sexually charged environment, an environment where people are telling inappropriate jokes, having inappropriate pictures in their lockers or on their desk, or perhaps on their computer, that they're making people feel uncomfortable. And same sex, different sex, doesn't matter. You're making somebody feel uncomfortable. Now, we all remember the news stories. Maybe 10 years ago, there was a fireman or firewoman, it's fireman, I think, who had a cheesecake picture in his locker. And a female firefighter said, that makes me uncomfortable. And back in the day, before we kind of understood this a little bit better, a lot of us shook our heads and said, well, that's crazy. I mean, it's a firefighter's locker, right? But we've started to realize, no, wait a second, that's not right. People should not be made to feel uncomfortable at work. Okay, so we're managing that. Most of us are counseling our employees. We don't want to have dirty jokes at work. We don't want to have R-rated pictures circulating in emails. We don't want to ask people about their love life, okay, during the weekend. That's all verboten, okay? We're learning that, most of us. But now apply it to the housing context. Now we're expected to be responsible for all the conduct of our tenants. Once again, can you imagine how do we provide for this in our leases? Are we ready, Holly, for a change to the AIR forms right? That the tenants...
I'll bring that up to CAR.
That there won't be any dirty jokes in the hallway, or somebody won't read a Playboy at the pool. Oh, is that still... Maybe maybe that's
I think
gone.
you're aging yourself.
Some other... Yeah, I just dated... A girly magazine or a boy magazine at the pool. Well, that may make other people uncomfortable. Here's what really gets fun. And when I leave you, I've got to go back to my office and rush a written testimony because tomorrow the State Fair Employment and Housing Council is meeting here in L.A. And I'd planned to spend the whole day there testifying and observing. I can't do it. I have these clients who want me to do things like work. So one of the things I've got to talk about is this hostile environment because we don't know what that means in the housing context. Now, if a tenant puts a poster of again, I'm going to go back to my day, Farrah Fawcett in their window because they like Farrah Fawcett, and somebody else walks by and they're offended by it. Okay, is that a hostile environment that they've just created in your apartment building? We don't really know the answer to that. We would think it would be if we apply the employment context. So the bottom line is we don't really understand how we're going to comply with this law. The Fair Employment and Housing Council, I've had a lot of interaction with them over the last several years as this has been going on. They have been working for at least 3 years now on drafting and adopting regulations on fair housing, which we've never had in our state. But one of the problems with that is that right now it looks like for the most part they're adopting lockstep the regulations of HUD. So I've begged them not to adopt the hostile environment standard. Well, but they feel like they have to because the feds have, greater jurisdiction, greater authority. And so what the chair of the Fair Employment and Housing Council told me a couple months ago in an email was, well, help us maybe better define what HUD. Well, how do you better define something that's unenforceable? So I just want to alert you, I don't have any answers, but just know that these federal regulations are not only not going away, California is almost certainly going to come in lockstep right behind them and follow the very similar standards. So be alert as managers, investors, owners of commercial properties involved residential. I think that's the reason why I've talked so long about this. I'm not going to talk this long about any other of my topics. They'll be much shorter. But I really do think that of all the risks that we face in residential and commercial real estate and in homeowner association law, frankly, I think this is the biggest thing to hit us in a long, long time. And the other shoe has not dropped yet. It's going to. And I just hope that none of our clients in South Bay Association or my other boards that I work for are going to be the first test cases. Sorry, Mo.
That's right. Thank you, Kelly.
Mo, if I can just add on to that. I mean, I completely agree with Kelly, and I think that this is a wave of litigation that hasn't even begun, and it's going to be a tsunami. So if you can try to figure out how to avoid being a test case, because we do have to wait until the case law filters all through, and it'll be years before that happens. But, you know, if you're the test case, then nobody has any idea how to even defend you. So, you know, I would say if you get into a situation like that, you need to really find some counsel who's going to help you get through that.
Yeah, one of the fun ones, if I could just add, I told the council 6 months or a year ago, last time I was in front of them, you know, in the HOA world, there's a statute, a free speech statute that says a resident of an HOA has a right to put a non-commercial sign or banner in their window or on their exclusive use balconies, okay? So non-commercial. So that means not advertising my business, but it could mean I think fill in the blank is super hot, or a picture, a bikini picture, okay? That is specifically protected by the Davis-Sterling Act, okay? Now, the HUD regs specifically prohibit that, because I think we'd all agree that creates a hostile environment for the neighbors. And I asked the council, who's going to win that one? And they feel like they can't contradict the HUD reg and carve that out. So it's going to become part of the California reg too, and we're going to have two diametrically opposed statutes. It's not the first time, but we're going to have that on this one. Sorry.
All right. So, Kelly, a little earlier you talked about passive removal of contingency. Could we talk about that? And also, is it legal?
Yeah, so I get this question a lot. You know, I'm the lawyer for RE/MAX, and my agents come across a lot of people who want to passively remove contingencies, which, as you remember, I already said, is when you just kind of let the time go by and the contingency period is over and the buyer didn't complain, and so therefore that contingency is gone. And people think you can't do that. It's illegal in California. It's not illegal. It has nothing to do with California law. That's just how the CAR form is set up to be an active removal of contingency. The AIR form, on the other hand, is passive removal. So what I see people doing is that they try to be creative, which my agents, there's a couple of them in here, know how I feel about agent creative writing skills. You're not as creative as you think you are, okay? So when you are writing things that are more than about 5 or 6 words, you should ask your manager, what am I doing, okay? Or you should take whatever creative writing that you've done and you should hand it over to somebody, give them no background story and say, can you read this and see if it makes any sense? And when they read it and look at you and say, huh? Then you know your creative writing was not as good as you thought it was, okay? Most of the time, people just use the CAR forms and they're fine, but sometimes people try to convert a CAR form into a passive removal contingency form, and it's not set up for that. So I would strongly recommend that if you're interested in passive removal, you need to move to the AIR form. It's not for your typical residential deal, but for your commercial transactions, it's a great transactional form, and it has the passive removal. If you are getting counter offers to CAR forms that talk about automatic removal of contingencies, you should have a conversation with the other side and say, look, this doesn't work on this form because one little sentence doesn't change the entire form. And we went through a period with the REO transactions, gosh, it's been 8-10 years now, where the REOs essentially cut out all that stuff from the CAR forms, but they had like 3- and 4-page addendum attached to it to do that. And that's what you really have to do. So passive removal is allowed. It's perfectly legal in California, but don't try to do it with the CAR forms, because what you're going to do is create a bunch of ambiguity and vagueness in a form that's perfectly fine on its own, and then that just creates problems for you as you get further down the road. So passive removal, stay with the AIR. Active removal, stay with the CAR.
Thank you, Holly. So, Blake, let's talk about commercial 3-day notice in reference to the differences in legal requirements versus the residential, please.
Yeah, so when we're thinking about kind of a big picture to think about in the commercial context, it is easier to get 3-day notice for non-payment of rent. We don't have to abide by the precise sum of rent rule, and we also can ask for rent that's over a year old. So in the 3-day context for residential requirements, it's very strict, okay? When you're giving a 3-day notice for non-payment of rent, you have to say exactly which months haven't been paid, but also can't be asking for more than you're due. So sometimes people may say, well, look, my lease says that I can charge late fees or attorney's fees to serve them with the notice. So when I'm giving them the 3-day notice, I'm going to add all that up so that everything's equal, right? In an eviction courtroom, if you go in front of the judge and you've used a 3-day notice that asks for as much as $1 more than you're owed, they could throw it out. All right, it's a month and a half, 2-month process, and if you rely on a 3-day notice that includes late fees and attorney's fees, they're going to laugh you right out of there. Okay, that's residential. Commercial, it's not like that. It's a lot more laxed, just because by the nature of the commercial context. What they say, what the law says, is that it needs to be reasonably calculated. Okay, when you put the amount of rent that's owed to you in the 3-day notice in the commercial context, it needs to be reasonably calculated. And what that becomes, it's a question for the judge, is to say whether you're within about 20%. All right, you can go up to 20% of what you're owed, and you could still be okay. All right, that's a lot of leeway. And why would they do that? Why is it so much more laxed? In the commercial context, there's a lot more things that go into just the rent, right? It could be based on revenues. It could be based on the taxing authorities, how much the tenant's getting hit up, and what their share is, and the CAM, and all that. So there's just a lot more moving parts in the commercial context, so that's why they allow that type of leeway. If you're within the 20%, then it becomes a burden for the tenant to prove that there was an unreasonable amount, that why you're wrong. So that's a question for the judge. And again, on the residential context, it's limited to a year. All right, if you're a landlord in a residential context and you wait for over a year to get that rent that was paid back in the day, you're going to small claims. They're not going to let you do it in the much faster unlawful detainer process. In the commercial context, that's not necessarily the case. We got to look at the lease. Normally what the lease says is that any money that I'm going to take moving forward gets applied towards what you've owed. So if somebody doesn't pay in January, but they pay February, March, April, May, and we sue them in July for what was done in January, really the money that was collected over those months gets applied toward what was owed. All right, so it keeps moving. The dot can keep moving. In the commercial context, that's almost always in there. And that's why, if that's the case, you could be outside of a year, but because of over that year you've been applying payments towards what was already owed, you could be outside of, you can make it past that 1-year rule. Residential, it doesn't play out like that. But again, really what it comes down to is looking at the lease and making sure that it says exactly that. It's going to explain how we're going to be calculating the amounts, but also how it's going to be applied if you're late or your tenant misses a payment.
Great. Thank you, Blake. So, Kelly, I just saw this recording fees. Now, starting January, there are recording fees for some cases?
Yes. Yes. Before I speak on this topic, I need to know, do we have any CAR directors in the room? We do have one? Damn it. All right. Well, so I have to be polite. This is...
No, you don't. He's one of mine. You don't have to be polite to him.
Is that? Okay. Well... I do recognize his contribution to CR, which has been rather substantial.
Yes,
so I'm going to moderate my remarks. I have a somewhat jaded opinion of this law and how it became law. This was a process that was several years in the making, as the legislature in our state was struggling mightily to create a massive affordable housing fund. And one of the ways they proposed to do it was to have a $75 per document recording fee on everything in the state. Well, our organization has always been adamantly opposed, as a matter of doctrine, to anything that would make real estate more expensive for people to buy, sell, maintain. So initially, our organization opposed this. Well, the legislature came up with a very brilliant strategy to gain our support. What they did was they said, hey, we're going to exempt buy-sell agreements from that recording fee. And so there, see, we're not adding to the cost of people buying a house. And it was a controversial move. I was in the housing committee meetings when we argued very vociferously about this. It was a split vote. The CAR leadership was very much pushing support for this, which I still feel to this day was against what we're all about, but it passed. And so the legislation then passed, and effective January 1st of this year, any document with some very small exceptions, buy-sell agreements in the state of California now has to have a $75 additional fee. And this fee goes to a housing affordability, affordable housing fund. And oh yeah, I forgot a big detail. CR was told they would have a seat at the table deciding how the money was spent. So, anyways, that's what's happened. Here's how it affects all of us in commercial properties. I think it's not going to affect you as much as in residential, but every time somebody records a mechanics lien, it just got $150 more expensive because there's going to be $75 of recoverable costs going on and $75 of recoverable costs, don't forget, taking it off. Mm-hmm. Every time you have a homeowner association assessment lien against somebody who's already having financial trouble, it's $150 more on the back of that homeowner. Common area alteration agreements, easements, covenants that we have in properties all the time. When in commercial properties you have issues of encroachments, how do we hopefully, real estate lawyers, hopefully how we work it out is not by going to court, but figuring out some creative easement to let live and let live. Those are going to be an extra $75 each and every time we do it. So that's just the way it is. It is law. And it's not going to hit the big transactions. You won't even notice it. But it's all the tens of thousands of little transactions each month that are going to add up. And then there's going to be this huge pot of money, and it's going to magically solve our housing supply problem. Right, everybody? Okay.
Actually, I got a quick comment on that. We're talking about the commercial context and the $75 fee. In the everyday context, a legal value firm, we do a lot of estate planning. And one of the reasons why they charge the $75, like Kelly was mentioning, a lot of those things that we're filing have to do with real property, has a connection with real property. What's been happening now, and we no longer do this anymore, is filing a power of attorney at the recorder's office. Anybody think that that should be charged the $75? Does that have anything to do with real property? Mm-hmm. I would say no. LA recorder's office would say differently. And what we usually do on our powers of attorney is we nominate the agents, and we also have a nomination of a conservator. So now when we file our powers of attorney, it's an additional $150 to do so. So that's just something on the personal end when you're doing your estate planning, that $75 crosses all barriers.
Thank you, Blake and Kelly. So, Holly, back to you. Let's talk about remedies under AR contract that are different from CAR.
Yeah, so most of you probably are aware about the CAR remedies. If there's a problem with the purchase agreement, the first thing you do is you guys are the front line, right? You try to negotiate with the agent on the other side, and if that doesn't work, you go to mediation, and if that doesn't work, then you guys look to see whether your clients have signed arbitration or not, and then it's either court or arbitration. AIR doesn't have that same process. You guys are still the front line, but they skip mediation. They go straight to either arbitration or court. And I can tell you that from a legal perspective, someone who's in the trenches with you regularly, mediation is an amazing tool. I would say, and you guys may be able to speak to this, but I would say 95% of the disputes that happen with our clients settle at mediation. It's cost effective, it's faster, it's how fast can you get everybody's calendar together. You're not talking about a judge, you're not talking about lots of discovery. You usually go into the mediation, you spend a day, the mediator bounces back and forth and basically discovers information from one side to the other and tells them, hey, this guy has this document or this email that says that you told him you would do that and now you're not. And it's quick and not so painless, but it's quicker, and people want to get things resolved, so they're motivated when they're there spending a day out of their job, out of their home, whatever their normal routine is, they're motivated to get it settled. When you take that process out, now you're hiring one of these guys, right? So now you're not just hiring an attorney, because I think you should take an attorney when you go to mediation, because as much as you think you know what you're doing, as an individual, you're emotionally tied to the process. So I think having an attorney who's not emotionally tied helps to settle the deal. It's been my experience that when people show up to mediation without a lawyer, they don't settle. I'm going to repeat that, right? If your clients are going to mediation without a lawyer, the chances are they won't settle. That's been my experience. Your guys' experience too? Yep. So while you are going to have to hire a lawyer for mediation, it's not drawn out arbitration. It's not super drawn out court, right? So the lawyer's fees are going to be significantly less. And when you pull that out, like AIR has done, they've just never had mediation as a part of their dispute resolution. I think it creates a hindrance because it forces people to have to then jump into the bigger fish pond of arbitration or the even bigger sea of court and not have that. Now, that being said, everybody can agree to do mediation, and the courts often say, you guys got to go try mediation first, but it's not mandated by the contract. So if you are going to be using the AIR form, you might consider having somebody draft a little bit of language for you saying that the parties agree that they will try mediation if there's a dispute before they move into arbitration or court.
Thank you, Holly. So back to Blake. How does serving a commercial tenant different than a residential tenant in a practical sense?
Yeah, so what the law says is that the standard way to serve somebody in the eviction context is you do it by personal service, you hand it to them personally. You do it by substituted service because you can't find them, but there's somebody there who will accept on their behalf that's over 18. Or you do what they call the nail and mail. We've been looking for them, we can't find them, we posted it on the door and we mailed it to them. Now, in the residential context, this can be difficult. What you have to do is exercise your due diligence. You got to try, if you have a work address, where to find them. You got to try and find them at work. If they're not answering the door, right, they're not paying rent, they know why you're knocking on the door. We have to use a process server to do between 3 and 8 attempts. If they don't answer, then I got to go and get approval by the judge to do the nail and mail. All right, but if we do, let's say we do all of that, if you can't serve somebody actually at the property, then when you do the nail and mail, it's not going to apply to unnamed occupants. So what does that mean? That means you go through the whole eviction process, sheriff schedules a lockout, sheriff shows up, and they're there to remove whoever was named in the eviction. But what if they've moved somebody else in, or family members? Sheriff's not going to do anything with them. All right, so that's a practical problem that happens in residential all the time. In the commercial, one of the benefits is that, let's say we can't find the owner, but what are they doing in the commercial context? They need their doors open to run the business. All right, so doing the substituted service is a lot easier because they can't just shut the doors. They're really going to be they're going to be running the business, so you can leave it with the receptionist at the desk and do substituted service. Additionally, if the tenant is a business, is an LLC or a corporation, what else are they filing with the Secretary of State?
Agent for service of process.
They got to say who their agent for service of process is by law. So we could even avoid the mess of having to show up at the business, because sometimes you want the business to keep performing, right? As the landlord, you want them to keep making money because that's how everybody makes money. Maybe that's how they can then pay their rent. But so if they have to file with an agent for service of process, then you just send it there on the 3-day notice, and service is completed. So that's where practically in the commercial context, because of those things, it's easier. It's just easier to get it done.
Thank you, Blake. This next question is important to me. I know Holly has beat this to death. We're going to talk about it in detail. Kelly is going to talk about it, and that's dual agency. You know, it makes the hair stand up in the back of my neck, but I know we do it all the time. But if we can spend a little extra time, I want you guys to understand the RP, you know, BS, all those forms that you sign. I don't know, I'm not sure. But Kelly, would you talk about dual agency and how dangerous it is?
I don't have good news. The law in California on dual agency in the courts continues to move inexorably toward a direction that many agents don't want to see. Brokers probably should actually, at the end of the day, rejoice. You may recall that the Michelle or Mickle case right down here from Palos Verdes was a frightening case from, gosh, about 8 years ago. That was a dual agency case where it was a residential case, but I think the rationale and the problem applies. That was the case where one agent had tried to pitch a property owner to list the property with him, and he did a little walk around, evaluated the property, was unsuccessful, put the notes in the drawer, forgot about it. Sometime later, and not just a couple of weeks, but sometime later, somebody else from that same agent's office actually did land the listing, and the property was sold. And somehow the buyer found out that not only there were problems with the property, but that there'd been this prior agent who had looked at the property and actually had notes on observations about the property, and sued and claimed that this was a violation of the dual agency this was a violation because that agent should be considered as the same as the other agent in this big office. And the court said, well, yeah, okay. Now that should have sent enough fear through large brokerages, but then the other shoe dropped in November of 2016, a case I'm sure you've all heard about, the Horiki versus Coldwell Banker case, where we now had a huge brokerage with multiple large branches, and we had a buyer suing the broker saying both of your agents in different branches who didn't even know each other are considered dual agency because, yeah, the buyer and the seller were both with CB, but one was with the Malibu office and one was with Beverly Hills? Yeah, Beverly Hills. Okay. And so we are going to consider you the same brokerage and therefore dual agency, and therefore, guess what? All the knowledge that the one agent has is imputed to the other agent because you're all under the same umbrella. Now, we watched this case, we lawyers watched this case as it wound its way through the Court of Appeals. We all cast bets on how this was going to come out. CAR, as you might imagine, put a lot of effort into this. But the bottom line was that the courts are absolutely unsympathetic towards dual agency, and they absolutely are willing to say that a giant brokerage like this CB brokerage is one shop. No matter how many offices you have, no matter how many thousands or hundreds of agents you have, one shop, okay? Now, I think that should strike panic in the heart of any large brokerage, number one, and number two, any brokerage, large or small, that allows dual agency to happen in their brokerage. Because whether it's in the same exact branch or other branches, all those disclosure obligations are going to fall on you as if the single agent represented simultaneously buyer and the seller, okay? Now, the CR's official statement on this, and I'm a member of CR, but I think CR tried to downplay the impact of that.
I would agree.
And that concerns me, and I think you should be much more concerned than what you have been told. I think that the courts are absolutely headed toward a path where it's not going to be that many years. We're going to find that the dual agency is going to become impossible, and it would not surprise me in the least if at some point a legislature in our very blue, consumer-oriented state is going to say, this is outrageous that we even allow dual agency in any context, commercial or residential. Imagine, remember, who are the people that are making the laws and deciding the court cases? Lawyers. Can any of the three of us simultaneously represent people on opposite sides of the transaction? Of course not.
We call that malpractice.
We call that malpractice and probably suspension of our license. So our colleagues are the ones addressing dual agency and making decisions about this. So how positive do you think you should look at the future of dual agency, knowing that the people who are interpreting it and applying the law to it are not allowed to do the same thing? Okay? So I think there are practical reasons, political reasons, and I think we just have to be honest. Okay? I'm a non-practicing broker, okay? So I'm one of you, but I'm not competing, okay? But let's be honest for a second with ourselves. If our commitment as realtors, commercial or residential, is to give our very best effort to our client, to fight for our client, to get the best price for that side of the transaction, to protect our client from the other side, how the heck, and I wish I could say something else, could we honestly do that if we're representing both sides? We can't. You're watering down what makes you valuable. So that's why I say I think the Horiki case is not the end of the story. I think it says two things. Because it follows up really on the Palaverdi versus Michael or Michelle case. It means that large brokerages are going to start having to do exactly what I do in my office. Is that anytime somebody calls me for a consultation or hires me for a case to write a contract, whatever, guess what? My assistant puts them in a database. When opposing counsel, Holly calls me about a problem with her company and one of my clients. Guess what? Her name goes into my database. So that any time a new client calls me, I pull up a search of any of the names involved. Now, I really think that large brokers, I very strongly believe this. I'd love to hear your comment on this, Holly. I think that the prudent broker is going to have to start keeping similar databases and basically doing a conflict check. And I think we can all spin it as a positive because we've been in the South Bay for 35 years. We have records on some properties going back multiple sales. But I think because of the Palo Verde, Michael case and Horiki, I really am suggesting that brokers seriously look into starting a conflict database, and that might have alerted. Well, I don't know. Would it have alerted Coldwell Banker? Probably not, because nobody really dreamed that two completely different offices would be considered the same.
Well, and that fact pattern was so bad.
Very bad.
So bad.
Yeah, there were bad things that happened there.
If I could just follow up a little bit on that,
Absolutely.
just because I am a big broker, a representative from a big broker. One, Horiki is supposed to be back in trial this month, I think. So it'll be interesting because it was sent back down to the courts again. So it'll be interesting to see. Secondly to that, Coldwell Banker really tried hard to settle that case. But the buyer is super wealthy and didn't want to settle. So Coldwell Banker really didn't want this to manage its way all the way through the courts and end up with being this test case. But they kind of got stuck with it. So dual agency, as you know, commercial agency changed last January, and suddenly you guys had to start doing the AD form in all your commercial transactions, so that there is now no transaction exempt in California for the AD form. Everybody has to use it on every transaction. And that was pushed by a brokerage down in San Diego, I think, that does only non-dual agency transactions. So they have also been pushing this law to be moving through for commercial to be non-dual agency. So I do want you to know that there is a firm out there who is really pushing this. It's not just bubbling in the legislature. There is a firm that already only does single agency, and they are pushing to make this move forward on the commercial side. I don't know that I see it in the near future, but I do think it will be something that the legislature will give some serious evaluation to, at least from the commercial side. As a large broker, what we have instituted, and I know multiple brokerages in California are also instituting this, because we have 700 plus agents. I'm looking over here to one of our brokers. 700 plus agents. We have 17 offices. They are split up into different brokerages, but because we use basically the same name, people think we're one and the same, so we kind of act that way a little bit. But we have a transactional platform online, as many of you probably do with your brokers. So we now have a process whereby when we get a new listing or a new client, we have an administrative person who runs that through our system, and we pull up the old file. Now, our files, we only keep our files for 5 years. We don't keep them forever. So while we have been doing transactions forever, BRE, soon to be DRE again, or whatever they decide to call themselves soon, they require 3 years. We have only been on our transactional platform for 4.5, so we've been doing it, we're saying 5 years for now. I don't know if we're going to be scrubbing our files when that 5-year line comes around, but for now, we are pulling the disclosures. We're pulling all reports, all disclosures that the seller has completed, and we are turning around and we are going to hand those off to our new buyer, and they will be uploaded into our new file for our new transaction that's going to be going forward. So if you are in a brokerage that has lots of dual agency going on, this may be something for you to be considering. I can tell you that without saying names, there is a brokerage in town who has not taken that position, and they have actually taken the opposite position of, no, we don't disclose things from previous transactions, even when that personal agent was involved in that transaction, and it has cost them a lawsuit that we are on the other side of. So I would not take that position, because I think Horiki and the other Palos Verdes case, they speak to not taking that position in any way, shape, or form. I think you need to be protecting yourself. Your brokerages need to protect you as well. And the way to do that is always disclose, disclose, disclose. So if you are dual agency, be it single human or 2 agents involved, you need to find out if your brokerage was involved in that transaction before, in that property before, because if so, you need to consider figuring out how to get those documents, because your clients never keep anything, right? I mean, you say, do you have that stuff from when you bought two months ago? And they go, I don't know. So, so you need to figure out where that stuff is. And then also to kind of follow along the ethics comment that was sort of alluded to there, one of the things that I see as a real problem on particularly the commercial side, I don't know why our commercial agents do this, but I have the 4-finger rule in my office. So if you think about the 4 parties that are in a transaction, it's the seller, the listing agent, the selling agent, and the buyer. You can only ever be 2 of those, and you have to be connected. So you could be, the agent could be the seller and the listing agent, but then you can't actually represent the buyer because there's just no way that you can do that, not just ethically or morally, but legally. Your fiduciary duties, you can't make that happen when you're also the seller. You could be the 2 middle people. You could be the listing agent and the selling agent, at least for now, right? You can do dual agency, or you can be the selling agent and you can be the buyer. But what I see commercial agents try to do is, I'm going to list this property for my seller, and then I'm going to buy it. Those 2 fingers aren't connected. You can't do that. You are now the listing agent, so you represent the seller. And if it's a deal you can't pass up, what do you have to do? You can't just resign. You need to find another agent. Because when you resign, who's the seller looking to for advice? You still, right? Because you were their agent. And it doesn't matter that you don't have a contract. You're still their agent because agency isn't created by a contract. Agency is created by what you do. Relationship, right? The more you act like their agent, the more you are their agent. And you guys can't shut your mouths. Right? You talk all the time. That's why you're great at what you do. Okay? But when you do that, you're creating agency even when you didn't mean to. So when you want to buy your own listing, you have to not only walk away from the listing, you need to make sure they have representation. And if they say, but you were going to offer me this price so I can't pay it, then you pay the commission to the listing agent because you need them to be represented. Or else you're going to end up, not in jail, but it'll feel like it because your real estate license will be revoked. Sorry, that was my 2 cents.
Good job.
Longer than 2.
That was great.
So if you take anything away today from this, I've been doing this is my 16th year. Take this to heart. If it's your first day starting this, really take this to heart. Next time it comes across your desk, take a breath, think about it twice before jumping in, at a cannonball. Don't do that. Think about it a little bit. It's not that hard. It's easy to say, something, I'm going to suggest somebody to help you buy this property.
You can get a referral fee.
Absolutely. I was just going to say that. I've done that. And it's good. You sleep easy at night. You don't worry about it. You can't worry about that $15,000, $20,000 commission check if in a year or 2 or 5 years you're going to end up in front of a judge paying it back and then
some.
And then your broker will probably say, oh, we don't cover that. Good luck. So I hope we beat this enough to death today. So back to Holly. So let's talk about these contracts, ARR and CAR. Do they sell the same thing?
Sort of. Okay. They're both selling real estate, but there's personal property that's involved with real estate, right? And you guys all know paragraph 8 of your CAR contract, and you've got this laundry list of things that are included. Window coverings, air conditioners, whatever the things are, right? There's a laundry list in there. You can check the boxes for the various appliances, right? That list does not match the list in the AIR form. So the real estate is obviously coming along, but the personal property may look different. So your clients, if you're going to move to the AIR form, well, you should do it on either contract. Your client needs to look at that laundry list and make sure that they actually want to be selling those personal property items along with. Because if they don't, then they want to exclude it. The thing I always say to people is, I actually bought a house one time where the bedspread and the wallpaper and the curtains and the shower curtain all matched. Right? That was like the 1980s, right? 1990s. Laura Ashley, whatever it was, right? Everything matched. Coordinated, that's right. Yeah. And when you sell that house, the curtains stay. Right? The curtain rod and the curtains stay. you can take the bedspread and you can take the shower curtain, but the wallpaper and the curtains stay. So your clients need to figure out, do I want those things to stay or do I not, and do I need to exclude things? The AIR form, because it's really developed more for larger complexes in retail and commercial, you know, most people assume that all that personal property belongs to the tenant. And so we're not selling any of the personal property except what we really kind of think of as a fixture, but we're not sure that it's a fixture, like a fountain or a security alarm system. But otherwise, the assumption is all that personal property belongs to the tenant. So your clients really need to take a hard look at what is actually being sold with the real estate. The disputes that come up over personal property are crazy. But I wanted that concrete elephant fountain that's in the front yard, and you took it with you, and you weren't supposed to. Or I wanted that beautiful fireplace pit that's all rusted out, but I liked it, and so you now have to return it. So, and refrigerators, I mean, how many of you bought a refrigerator for the client because the seller took it with them, the tenant took it with them, they weren't supposed to, right? So really, personal property is where the problems lie, not with the real estate. Title company works out that problem, right? But the personal property, you really need to pay attention because the two are not the same in that respect.
I would suggest that if you still have a completely coordinated Laura Ashley bedroom, it's time to let it go.
And I dated myself by using that reference, right?
We did. We had one of those. A long time ago.
All right. So, thank you, Holly. Back to Blake. So what happens if a commercial landlord accepts a partial payment of rent after the expiration of the 3-day notice?
So it's a lot easier in the commercial context, as I had shared. We've got to look at the lease, all right? Has anybody dealt with an eviction before? Have they actually pursued one? Okay. These courts, I call them kangaroo courts, all right? Sometimes if the judge is having a bad day, we're having a bad day, right? So in the commercial context, it doesn't usually play out as hard because, like I said, we look at the lease because normally the lease is going to say if you accept late payments in a commercial context, it gets applied toward what was owed. And so it won't necessarily invalidate the 3-day notice. That's a general idea, all right? Look at the lease and make sure. In the residential context, it's much different and much more harsh to the landlord. I actually gave a talk here, and one of the realtors brought up a story where she owned some property and she was bringing her own eviction. And the day before trial, the tenant direct deposited into the account $1. $1. The landlord shows up the next day, and the judge asks, well, did you accept partial payment after the expiration of the 3-day notice? And she said, no, I didn't even know that they did that, right? The tenant shows up with the receipt showing the $1. But the judge didn't agree. It was acceptance of a partial payment after the expiration of a 3-day notice. In the residential context, threw it out. All right, so the 3 days.
Do you have a recommendation about direct deposit?
I sure do. All right, so I heard the story here, and so I kind of changed. I worked that into me talking with my clients, is let's keep that from happening. If they're doing direct deposit, that was great. Now it can hurt you. Shut those accounts down. Okay, keep them separate, shut them down. But I have another horror story to share with you, is I had a client in the residential context who did that, all right? They were behind like $2,000 or $3,000, shut down the account that they were doing the direct deposit for. The tenant went to go pay about $800 of it, so less than half, and it got rejected because there was no account. She went to the bank, told the teller, I'm just trying to pay my landlord the rent that I owe him, and he said, well, here's the new account. Let me help you out, and allowed her to do it. And so I turn to my client and I say, we may have another lawsuit against this bank, but in this residential context, if I end up in front of the judge on this, we're in trouble. I know you tried, but we need to try and work it out. We were able to work it out. But that's just something to think about. In the commercial context, much more lax, as long as the lease says what they normally say. We're going to apply any later payments towards what you owed, so it's not going to throw the lawsuit out. But in the residential context, the judges don't care.
Thank you, Blake. So, Kelly, I know this has been the news for the past few years. Talk about bed bugs.
Okay, so I'm going to be watching closely to see if anybody uncomfortably moves in your chair as I'm talking about this. So you probably heard that last year, new Civil Code 1954.603 became law. That required that new tenants receive a bed bug disclosure. The big thing now is that it's effective this year. You've got to, as of January of this year, you've got to make sure that all existing tenants, not just new ones, have the disclosure. And in reading this last night, everybody, put down your muffins before I read. Information about bed bugs. Bed bugs have 6 legs. Adult bed bugs have flat bodies, about 1/4 of an inch in length. And then it goes on down. Bed bugs can survive for months without feeding. Common signs of a possible bed bug infestation. I could read it. It would ruin your whole morning. I read this and I was so creeped out, I thought, do I even want to talk about this? Once I read this disclosure, and I was debating what to say about it today, after I read the whole thing, I thought, I never want to stay in a hotel again, ever. Anyway, that's the change. Make sure that your commercial rental owners, managers, this should have already been distributed to all tenants. And I can just imagine the backlash, when 100 tenants in a building in January this year all got this disclosure and immediately freaked out and said, why am I getting this? So if you haven't done it yet, it needs to be done. I would not just give them the disclosure. Please send a cover letter. This is being sent not because our building is infested with bugs, but the statute requires it. A new law requires it, so you're getting this as a required disclosure. That is all. Okay? Don't just send it without comment.
Who's in charge of getting rid of them?
Somebody other than me.
Thank you, Kelly. So back to Holly. What's the gotcha that hits most of the agents when using CAR contracts, but then go to use AR contracts?
Well, I think you guys, I was going to say you know your forms, but you probably don't actually know your forms very well based on some of the questions that I get. I think that you guys need to read your forms better, but I think that you're familiar enough with your CAR forms that you're used to certain processes, right? You're used to it's 17 days for this, and it's 21 days for that, and I have a 2-day notice to perform and a 3-day demand to close escrow, right? Those are all kind of our standard things. We're used to those procedures, and the AIR forms don't have that at all, okay? So you need to really pay attention, and this is where agents get, they get into trouble because you're not, the day count is different. The notice to perform process doesn't exist. Because of the passive removal of contingencies, there's no reason to do a notice to perform because the contingency expires on its own, and when it expires, it's gone. So unlike in the CAR form where there is really no expiration of contingencies, although I hear you guys say that all the time, we're out of contract. I want to know, are you stepping out of the contract? Because I don't even know what that means, right? There is no such thing as out of contract. That's why the lawyers are laughing up here, right? So you may have a contingency period that has gone past, but the CAR form says if it's gone past and nobody's done anything about it, it's just going to keep going forever until you do something about it. And the AIR form isn't anything like that. If the contingency period is done, the contingency is done, and you're moving forward to the end of escrow. So all those normal procedures and day counts that exist in the CAR form don't exist in the AIR form. So if you don't typically write out your dates on a piece of paper when you do a contract, if you're using AIR, you really need to do that. You need to write out your day of acceptance, you need to write out when each contingency expires, and you need to be on it so fast all the time, because otherwise the potential buyer is going to be stuck in a contract that they may not want to be in, and they're going to turn to you and say, why did you let this happen?
Thank you, Holly. Blake, so are there fewer protections afforded to commercial tenants when compared to residential?
And I would say absolutely. And the biggest one, right, the difference between commercial tenants and residential tenants of what the landlord has to provide, there is no implied warranty of habitability. All right, that's major. In the commercial context, it does not apply. In the residential context, it's something that hurts the landlords a lot, and it becomes a he said, she said type of battle. And essentially, what that rule says is that you have to give a place where the person's going to be living that is, I'm looking for the specific wording from the case law, legally responsible for repairing conditions that seriously affect the unit's habitability. All right, and this was initially case law that was codified. And really what it comes down to is, what does the landlord have to give in the residential context to its tenants? All right, there has to be adequate electricity, gas. There has to be trash receptacles. They have to clear it of bed bugs. They have to make sure they disclose if there are any of those issues. A lot of the things that I see every day as a kind of a blanket defense that the tenants like to bring up, the reason why I'm not paying rent is because of X, Y, and Z, and they try to drag it out just so they could buy some more time to find a new place to live. In the commercial context, it doesn't apply, all right? And there's case law as to why. The implied warranty of habitability is in the residential situation, somebody who's living there, all right? In the commercial context, we're running a business, all right? So the reason why the California law says that, California case law, the summary reasons why it doesn't apply is there's two major reasons. One is that it's anticipated that in the commercial context, the landlord and the tenant are on more equal footing. All right, they're at bargaining arm's length. They're usually represented. They're not living there. They're running a business. So they're kind of afforded the ability to figure out those problems on their own, as opposed to it just being codified and allowing the tenant to go after the landlord if they're not doing the right thing. The other reason why is that in the commercial context, there's more money involved. All right, because we've got the income for the business. We're renting out this commercial space. We should be afforded as the landlord to, hey, I've got this non-paying tenant. I need to get them out quickly. So that's kind of the general reason in the residential context. But again, in the commercial context, they don't want those problems to be arising in a commercial lease because it can be more easily negotiated. And that's really the bottom line on this. Because there is no implied warranty of habitability for commercial tenants, it really is incumbent on the tenants and the landlords to address these issues specifically in the lease. If there is some sort of expectation of electricity, who's in charge of it and who's fixing it and in what amount of time, that there's going to be gas, right? If we're running a restaurant, we got to make sure the gas is taken care of. Generally speaking, the landlord's going to kick that over to the tenant and they got to figure it out. As a tenant, they should be thinking about, well, if there is a piece of this that I'm not in control of as the tenant, I want to make sure this lease addresses it, because if it doesn't, and I end up in front of a judge that the reason why I'm not paying rent is because I don't have any people coming through the door because I can't run the restaurant, the judge isn't going to care. And in the commercial context, there is no implied warranty of habitability.
Thank you, Blake. Kelly, let's talk about the Supreme Court's decision regarding construction defects.
Sure. We actually had two big changes in the law that, whoops, I lost my identity. There are two big changes I'd like to talk about very briefly. One happened in January of this year regarding construction defects, and I want to make sure there's no misunderstanding of its applicability. Back in 2002, the legislature adopted a law called SB 800. It's been called since as the right to repair law. What it did was, on residential properties built and sold for the first time January 1, 2003 or later, it added a bunch of developer rights to try to go look at the property and fix it before it turned into a lawsuit, provided for mediation and even a form of pre-litigation discovery that nobody ever figured out how to use, by the way. And most importantly to residential property owners, shortened the statute of limitations of a variety of defects, most notably electrical and plumbing defects, I think probably were the worst issue. They shortened the defect statute of limitations from 10 years to 4 years. Well, that issue has been bandied about in the courts for many years since then. One of my clients, before she became my client, was involved in a Court of Appeals case where the court said, okay, well, this new law is one of the ways in which a residential property owner may get justice, but there's also the common law of negligence that can be an alternate path to justice or to recovery. Then there was another case that shortly after that, about 2 years ago or so, said, no, SB 800, the Right to Repair Act, is the only path to recovery for a residential property home buyer. The Supreme Court, in a case called McMillan Albany LLC, in January of this year, finally ended the discussion, we think, I don't think it's over, that they said, okay, the right to repair law is the exclusive remedy. This is the path to recovery for a residential property owner when they think something's wrong with the property. That appeared to end the debate once and for all. The problem with that is that there already are lawyers saying, well, wait, we don't think it completely closes the door. We think there are a couple of other theories that the Supreme Court left open. The reason I mention all of this is to let you know that all of this since 2003, when the law first took effect, only and specifically applies to residential construction. When I teach realtors in my GRI class on construction, I tell them in the afternoon that we, since 2003, have two separate systems of justice now in the construction law area, one for residential, the right to repair law, and one for commercial, industrial. That's the same rule we've always had. So you still have 10 years in your commercial industrial properties to sue for problems with the original construction. So just want to make clear that if you're troubled and your manager says we're having widespread system failure of the plumbing, the building's only 6 years old, what do? Don't be fooled by a contractor's attorney or a defense lawyer who says, oh, well, it's more than 4 years, haha, too bad. SB 800 never applied to you. The other law I just want to quickly mention is the marijuana law. Now, many of you here in the South Bay, good Baptist law-abiding people, probably didn't follow this, but the state of California legalized the personal use of marijuana in your personal residence, effective January 1, 2017, and now in January 2018, of course, you can have a pot store, right, if the city issues a permit. I just want to alert you, when you're dealing with commercial rental properties for residences, I'm already starting to hear rumbles in the HOA and in the tenant context. Oh, well, that proposition that passed a couple of years ago, that says I have the right to smoke weed in my apartment. Exactly, ma'am. No, you don't have the right. It took away the criminal penalties, and so you don't have the right to grow 6 plants. You don't have the right to smoke dope in your apartment. And if your landlord wants to modify your lease, and by the way, I'm already modifying CC&Rs, I'm adding a new use restriction. No marijuana plants are going to be grown in this association, and smoking of any kind, not just tobacco smoking, is not allowed. Alert, fair housing, somebody that needs to smoke medical marijuana for medical reasons, which, by the way, is less and less because of vaporizers, inhalers, and edibles, that would be a big carve-out. But don't let anybody tell you that you have to allow me to smoke dope, because the Proposition 64, I think, says I do. Okay?
What about in the common area?
What about smoking marijuana in the common area? The law does not protect that. The proposition that passed specifically applies to in your own personal residence. So the minute you step out on the sidewalk or out into the common corridors of the apartment building or the garages, you are now outside the protection of the law. Oh, by the way, I think you also have to be, is it 18 or 21?
21.
21, yeah.
And oh, by the way, it's still illegal under federal law.
Yes, that's what the Attorney General keeps telling us.
And the Attorney General has become very vocal about it in the last couple of months.
Actually, this reminds me, Holly, I had a client come to me, a commercial tenant. He had some kind of an appraisal business or something. I won't say what city. And he was very troubled because he had a long-term lease, and the building owner sold the property, and the anchor tenant and the owner of the building is a marijuana store. And so he was asking me, could he break the lease, because he didn't want, because they're cash businesses. They're not allowed to use banks. And so they have huge amounts of cash, which means they have to have armed guards. And this guy was saying, I have a respectable real estate investment firm. I don't want to have clients having to shove past big goons with Uzis. Very, very, very difficult situation for him. So some of us are going to be dealing with that. Well, the answer for him was to send a warning shot across the landlord's bow and ask to get out of the lease. And I think he had a pretty good shot at it, because it was really dramatically changing the character of the building. Yeah.
Guys, if we're going to do questions, make sure you raise your hand. You need the mic to do the ask a question.
Please keep them general.
Mo, can I throw one question to Blake really fast, just because we're talking about marijuana? I have heard that when tenants are smoking marijuana in their property and the landlord wants to get them out for that, that's becoming a problem in the eviction courts. Can you speak to that?
Yeah, absolutely, because it comes down to, like we said, like Kelly had mentioned, that if it's not specifically in the lease, right, if it says no smoking, and now we've got this new law that says, well, now there's a new type of smoking that's allowed in the residential areas, does it play to it? And when I've spoken here before, because of that ambiguity, lawyers love ambiguity. These two are saying, they're trying to identify the ambiguity so you guys can avoid it. But normal attorneys love the ambiguity, because then we do get hired to fight it out, and we'll figure out what's going to happen, right? He mentioned when his tenant dramatically changing the characterization of the property. An attorney's going to help figure that out. In these cases, the best thing that you can do, that landlords can do, is minimize these issues by addressing it in the lease, because if you're putting it in front of the judge, if you're trying to get rid of a tenant for breach of a covenant because they're smoking, but it doesn't say weed smoking, again, bad days for judges can be bad days for us. So as much as you can put in there to avoid a judge sticking their nose in it, that's how you can minimize a lot of this stuff.
I have a question regarding commercial property. If buyers spend money to the phase 1 environmental inspection and recommendation for the buyer to do phase 2 inspection, and the lender required the phase 2 inspection to fund the loan. Seller, buyer want the seller to pay, seller not going to pay it, and sellers already have a contract, they say as is, and have no knowledge about anything, but then seller say, seller don't want the pay, and the seller say he doesn't like the phase 2 have to dig the ground, everything, interrupt the business over there. So can seller refuse to do that? Also, buyers say they already spend $5,000, including the loan appraisal already done and the phase 1 already done, total $5,000. If seller doesn't allow the phase 2 inspection, buyer want to sue the seller to get his $5,000 back. Is that okay? Is that legal? Buyer can do that? Or can seller refuse to do the phase 2 inspection?
So I can speak to that. So buyers never have the right to get their costs back from a seller. That doesn't exist in any of the contracts we've talked about today, unless that's something that they include separately. That's part of the risk of going into a contract to buy a piece of property. So buyer may want to do that, but buyer is not going to succeed in that. That being said, small claims court is a crapshoot, probably worse than eviction court. So who knows? But they don't have a contractual right to get the fees back. A seller has, under the CAR contract, the right to say that they don't want to allow intrusive testing on their property. However, the buyer has the obligation to return the property to the state it was in before the testing. So my recommendation always is, as a seller, you should never say no to a test. Unless it's going to be a real complication to whatever businesses that are running at that time, the seller should let the buyer do whatever tests they want to do, because it is an as-is transaction. All the contracts are set up to be as-is in California. And all that means is I'm not going to do anything to the property for you, buyer. I may still have to do things for the state, retrofitting, whatever. That's not a part of as-is. But I'm not going to change the state of the property or the condition of the property for you, Mr. and Ms. Buyer. So let the buyer come in, understand exactly what they're getting, and that way, remember, it's a disclosure, right? Now they know, so later they can't come back and complain to you. So.
But what happens if there's anything need to be done after phase 2? Who's supposed to pay for? Seller to pay for or buyer to?
Seller's not obligated on the contract to do anything. Seller just sits back and says, yes, you can do it. And whatever comes out, you make a decision. Either you're going to move forward and do those things and buy the property, or you're not.
Okay, thank you.
Mm-hmm.
I have a quick question regarding new construction, like single family up to 4 unit. There's like a a CAR form that's an addendum. It's called the new construction addendum to the RPA. Now, in that addendum, it only talks about the seller giving a 1-year warranty. What is the real actual warranty that a seller should be giving on a new construction property?
That's just the 1-year fit and finish warranty.
Right.
That's just it's going to look pretty like this for the next year.
But if
as
there's
long as
major-
you're not doing anything wrong. But there's a bunch of other warranties behind it.
Right. So where do I find that? So I'm giving that to the buyer and the seller so they're aware of that. Because, example, I have a client whose new construction house keeps leaking, and it's past that 1-year warranty, so obviously that's not that part of it. So where does it say that the seller needs to keep fixing this? Because they should, obviously,
Well,
but they're ignoring them.
Fit and finish is not leaks.
Right,
Fit-
that's what I'm saying, I know.
That's scuffs and a cracked cosmetic
Right.
tile. There's this urban legend in the real estate community that in the GRI I used to teach. I used to spend like 10 minutes pounding, there is no automatic 1-year warranty. And then SB 800 came around and said, oh, now there's an automatic 1-year warranty, but it's bogus because it's only fit and finish.
Right.
That doesn't negate the fact that you still have the common law implied warranty that it was that it was built with reasonable care. Okay, if it was
Okay.
built for sale, then there's an automatic warranty that it was built with reasonable care. What means it wasn't negligently built. But now we have this issue where we don't know if the Supreme Court is saying, oh, well, have we now negated that common law claim for residential housing? That's one of the issues that the defect lawyers are going to be fighting about with the insurance companies for quite a while now, until the Supreme Court probably speaks again.
But
Okay.
SB 800,
Right.
there's a link in that
I know about that.
exact addendum. SB 800 says exactly how many years they have for roof and whatever all those things
Plumbing,
are.
electrical.
Yeah.
Well, the good news, roofs are not shorter. The water tightness is still 10 years. The big problems are plumbing and electrical. There are other lesser defects. I think the building industry hated the defect of wood posts sunk in concrete because they dry rotted within a year or two. So they just declared, 2 years to sue for that defect. Well, that isn't really it's vexing. It's a clear defect, but that's not going to ruin an apartment building. But if the plumbing system is failing, and a lot of times it takes 4, 5, 6 years to see enough of a pattern to call an engineer, okay, well, if in fact this McMillan case is what it claims to be, then you're out of luck in a residential context. Now, you have an apartment building, now you're different. You're still under the 10-year rule. That's what I'm going to say to you all, because this is a commercial group. Your commercial rights were unchanged by SB 800, unaffected.
But that's only
Commercial.
over 4 units. I'm talking about up to 4 units.
Well, residential 1 to 4, you're
Yeah.
you're squarely under the problem of the SB 800.
Okay. Thank you.
Can I just, since you brought up new construction, because people don't use the forms correctly, there are 2 forms for new construction, right? There's the new construction purchase agreement, which is what you use if the property is not going to have a certificate of occupancy before at the time you go into contract. The RPA with the new construction addendum is what you use if you already have a certificate of occupancy at the time you go under contract. And they are very different contracts. The new construction purchase agreement doesn't have an investigation right. There's no contingency there because it's new construction, so why do you need to come and browse? I mean, you can walk around and put your blue tape everywhere, but there's no contingency associated with that. The contractor has to keep it looking nice and fix it.
I'm going to add to that. If you've never written one,
I do them all the time.
don't write one by yourself. No, I mean overall. If this is your first time writing one of those new ones, find somebody in your office that's done it. Do it with them, because you got to protect your client. You don't want to be the test case the first time and you say, I did or not, I've never done that before. Please. Yes.
I had a question about referrals. If you have a situation where you go somewhat out of the area, let's say West Los Angeles, someone says it's a friend of a friend, and you go take a look at the house and you walk through it and say, it's a great house, but I really can't give you good service. You should find a local agent, and you refer to someone within your company that has an office there. Are you, at what point, if at all, are you an agent for that person, or are you completely relieved of anything once you've referred it over?
Well, the Mickle or Michelle versus Palo Verde Realty case would say that any knowledge that you acquired during that visit is going to be imputed to your colleague in the other office. I think you combine that and Kariki together, I think that's clearly the end result. So if you acquire information, you see something wrong, to protect yourself, I would document it to the other agent so that it's clear that you had the information, you gave it to them to protect both of you and the broker over both branches.
But for the agency itself, remember, agency is created by behavior. So if you have not actually been acting as their agent, you went over there, you said, yeah, this looks like a great neighborhood, but I don't know anything about it. We should get you somebody who's knowledgeable. So you haven't actually given them any real estate advice, then you're not their agent. From a referral agent perspective, RE&O covers referral agents, but we've never been sued on a referral. And I have asked that question of our E&O broker. They have never seen a referral person get sued, but we still have coverage for it on the off chance that somebody comes back and says anything.
What should the proper response be if they call you during the transaction and say, you know, I have a private transaction I'm not sure about, and I want to ask you a question about it? Should you just say, look, you know, talk to your own agent about it?
Yeah, I mean, definitely, because once they call you and start chit-chatting with you about the transaction, you're now acting as an agent. So you've now put yourself in the middle of the transaction, and you haven't done it according to the statute. So you haven't done an AD, right? You haven't been involved, so you're just talking off the top, and you don't necessarily have information about the transaction. Now, if they're just calling you and say, is it normal for my agent to be telling me that I have to remove contingencies at 17 days? Yep, that's what the contract says. Why don't we call your agent and have them talk to you about it further?
Does that usually happen to your friends? That they call you, telling you they use somebody else and they're asking you questions?
And you know who sues you first?
And you're
Friends and family.
Other questions, right? You're really helping them. You're becoming their agents without getting paid. Right. So expect a call from the other agent telling you to butt out. You know, if they're your friends, they could have used you. Otherwise, you know, stay out of courts. We get paid to talk. We don't get to pontificate law.
Well, it's more a friend of a friend or someone that you don't really necessarily know. At a cocktail party or something, you know, let's say I'm involved in it, what do you think? So the appropriate response would be, look, you have an agent, you should talk to them.
Yeah, I mean, it is interference with an agency relationship, and you can be brought up to the board on that, so be careful.
This is for Kelly regarding the HUD fair housing laws. With regards to the hostile housing offender, trend that we were talking about, do you see a tenant screening or a hostile housing offender list starting? Is that legal? Is that something that income property owners can look to put together in the future?
Wow, that's interesting. You mean somebody who has harassed other tenants?
Sure. Mm-hmm.
That's a fascinating concept.
I like the idea.
I don't know. I mean, the problem. What I struggle with is
a Megan's Law database for nasty tenants.
Yeah.
I like it.
Yeah.
Talk
Megan's
to CAR
Law
about that.
Yeah, and which of course we can't ask about Megan's Law status. See, that's what the list of things we can't ask a tenant or a prospective employee is getting so long. I ran afoul of it 2 weeks ago. I didn't know, and I learned this from an employment lawyer. We're hiring attorneys right now, and I asked an attorney what their salary history was. I've been doing that for 30
can't do
years.
That. No.
Exactly. I'm going to jail.
That's actually a new law that you have the right in California to go to your previous employers and get your salary history, but nobody can ask you about it.
Great. Yeah.
So you can claim you've been making $300,000 as a receptionist for the last 4 years, and nobody can say anything otherwise.
Yeah, but on a serious note, what I struggle with is that how often is somebody going to admit that they made an inappropriate remark? And how often, as a litigator, do I see two people who are both telling the truth but have completely different realities? Neither is lying. Okay? Somebody saw a look, and they interpreted it as a leer. The other person said that was an eye roll. It wasn't a leer at all. Now, who's lying? Because if I have a certain mindset, right, I'm going to interpret something in one way that was never intended by the other person. So this is going to require the landlord, the on-site manager, to make a determination about who do I believe.
Right, but the
And I
person,
wish you luck with that.
it gives power to the person that complains. And they could
Yes.
become, and they're looking for a payday or free rent or to get rid of somebody,
Yes.
and they could become the long-term problem moving from project to project.
Well, yes, and here, a true story about a client of mine years ago, they had, this is an employment issue, but imagine this in the housing context. This person, okay, let me just change it to fit a housing. This tenant moves in, doesn't create any problems for several years, is a good tenant, obeys all the rules, and then after a while, they become a terrible tenant, and eventually we evict them after giving them warnings and notice. Only after we evict them do we, the landlord, get a letter saying, I just want you to know, while I was a tenant there, the following things were said to me by other tenants, and the following things were said to me, and I was made to feel uncomfortable because of my male gender. And with exact quotes, and with printouts of emails that this person had received while they were a tenant. You follow me? And so the building manager did not respond to that. They're no longer a tenant. Why am I concerned? So the next was a letter from the lawyer saying, here is further evidence of the way my client was abused and made to feel uncomfortable while they were a tenant in your building. And very shortly after that was the lawsuit. It hit my desk when the lawsuit came in. Well, guess what? My client, by not looking into the allegations of misconduct, which, by the way, were all true. I had to interview all these employees, tearful. By the way, they were all women. Nice ladies, not brazen people, embarrassed because they thought he was their friend. And my client had to pay a pretty fat sum to this guy. What he was doing was, from day one of his relationship at this apartment building, he had been keeping a journal of every inappropriate thing said or done in his presence. And he was very accurate. And so my client's employees were all...
We definitely want him on the database list.
Yeah, you definitely want him on the database list. Yeah. So my nightmare is, because in the fair housing law on the employment side, you're required to investigate even after the person's left your employ. You're required to take reasonable steps, which may be counseling the offenders. Hey, this was inappropriate, okay?
That's
But
the interactive process.
the
you
interactive
mentioned
process,
earlier.
yeah. And so my client had failed miserably on this. So now imagine your on-site manager is going to be expected to investigate, pursue, even if the tenant said, I had to move out because it was so uncomfortable. If you don't investigate that and take whatever steps you can take, that actually may be the hook they hang you on in a lawsuit later. And it's a total setup. It was a total setup. It was not a legitimate thing, but there was nothing we could do. $100,000 were paid.
And if you think about who your on-site property managers are,
Those geniuses, yes.
and that they're the ones that are supposed to be doing this interactive process,
Let us pray.
that's scary.
One more question. Regarding the Hariki case, and if Coldwell Banker goes down and they're seen as one broker across, and we're trying to get rid of dual agency, do you see the breakup of large brokerages? Because you're at Coldwell Banker with a couple thousand agents, and now you can't sell any of the listings in-house.
Well, first of all, let's understand, the California Supreme Court has said they are all under one broker, and all that knowledge is imputed. So the only question is what the jury is going to do with all this. The rule has been enunciated. I think one of the great challenges to the mega brokerages, the multi-branch brokerages, is going to be how do they adapt to prevent these issues. I think long term, is it going to be before I'm retired? I don't know. But I think we're headed toward, the legal system is inexorably pushing us toward a situation where dual agency is at some point going to become impossible to do. It might be specifically legislated out. My guess is that there's going to be some legislator that hears of some process, some case history that legislator finds to be horrible, and he or she is going to put a bill in and say, why do we allow realtors to do what no other profession can do? A marriage counselor can't talk to one and then the other separately. There are ethics that even they have. They can't do that. They have to talk to them together. Or right? So I think that this is going to be phasing out, and it's just a question of when, not if, in my opinion.
Right. So then you would have to leave a Coldwell Banker, or a large brokerage like that, because you can't sell any of their listings as a buyer's agent, because then you're computed to be dual agent.
Well, that's one possible solution, exactly.
Yeah. So you'd have to go out and hang your license in a small shop. And
from a risk management standpoint, it's easy to me to say, because I'm not inside counsel, I don't have to struggle with what Holly does. But in the bleachers, I think the best approach is the database that you already heard Holly, which is very commendable. The database that they've got, but I think ultimately, the big brokers are going to have to take a real long look at how do they handle dual agency situations, because a database probably isn't enough. And this all may be as I said, I think ultimately it'll be taken out of all of our hands, and they're just going to do away with dual agency. So it could really affect the business model of the very large companies, because then their size could be held against them.
Okay, I have a question about late fees, actually two questions. Part A is, our residential lease states that past due late fees turn into past due rent, and so if it's from the month before, we want to confirm it's okay to include it in a 3-day notice. And B, our current lease states that there's a $75 late fee if the rent is paid after the 3rd, and then after the 5th of the month, $5 per day, which I understand is problematic. So I was wondering if you guys have any suggestions on how to legally incentivize tenants to pay their rent earlier rather than later, instead of just one $75 late fee, and then why pay it on the 5th when I can pay it on the 28th?
And that, I could speak to that. That's the million-dollar question, right? How to get your tenants to pay their rent. The problem on the residential side of it, if you're going to do a 3-day notice, it's only for non-payment of rent. So if you're going to try and collect on those late fees, it's not going to be with threat of eviction, period. Even if the lease says it, which is what you're saying. It's like, well, in this residential context, we actually put in there that it should be counted as rent. The judges aren't going to allow that. All right, the commercial context is different. But in that residential context, I mean, you put those penalties in, and hopefully it does inspire them to pay on time so they can avoid those late fees. But really, what you're going to have to do to collect on that, it would be in a small claims situation, or if it's someone you're having problems with that tenant and they're really just not paying, a couple days late, and you want them out. You know, you could give them a notice to leave, but that may be extreme, because normally, if you're getting the rent, not getting the late payments should be not as big of a deal. But I have had clients who are sick of it. They're sick of the games, and that they're incurring the late fees or not paying them. And if they've been there for less than a year, you can give them a 30-day notice. If they've been there for over a year, 60-day notice, assuming it's not a fixed-term tenancy. But I would avoid trying to use an eviction to deal with that problem.
The security deposit from all those late fees?
At the end of the day?
At the end, when they're reading it out, could tell you were late 5 different times through your tenancy, it's 75, 75, 75, and then just subtract it from their security.
You got to do the calculation. You got to give them a breakdown and show them. But that absolutely.
So I have two comments to that. One, about the late fees. What I'm hearing anecdotally is that small claims court judges don't want to let the tenants have to pay that. So if you remove that from their security deposit and they want to fight you on it and go to small claims, you might lose. Because their response is that you weren't actually damaged. You were inconvenienced, but you didn't actually incur any cost because the tenant was late. Now, it's different if you couldn't pay your mortgage because you didn't get the rent, and so you incurred fees. That's different, and you'll probably win that. But unless you can show how you were actually damaged as a landlord, what I'm hearing anecdotally in small claims is you're not getting the late fees. The second comment to that is that I am hearing some people deciding to incentivize the other direction. If you pay before the 1st, we'll give you a 10% discount. Right? That's an incentive. Now they're getting money back in their pocket. You're getting a little bit less, but then really your late fee is that 10%. So
can you address for a minute revising leases? So if you're purchasing a property and there's outdated leases in rent control areas that don't cover current laws, what rights you have as a buyer or a property owner to revise old leases?
In rent control? In rent control, good luck.
Good luck.
I mean, just good luck.
Yeah.
Outside of rent control, you can anytime, as long as they're not under a lease term, you can, as a landlord, say, here's your new lease.
And you should.
And you should.
If it's under rent control, isn't there some like expiration of the lease at which time you can then revise it, or does that not apply either?
Again, it depends on the lease. I mean, that's normally what you say. You got to look to what they had agreed to. You can't just invalidate it just because ownership transferred. So you got to abide by it. But in the rent control area, it's heavily controlled, and so you got to make sure you're using the right attorney for that stuff.
The lease term may be ended, but they're month to month under rent control, and you can't change the terms of the lease except for the rental amount by that little teeny tiny percentage, is my understanding under rent control, which is why we say
Can
good
you
luck.
please address the comfort animal and the, let's see, it's a comfort animal, and
Do you
then
wanna
the
talk
other
about
one
that?
is, thank you, the service and support animals in residential and commercial leases.
Okay, this is a topic that the proposed regulations are being discussed tomorrow in downtown LA. If you're really interested in this, there are two very different concepts, and they're mixed up all the time. An assistive animal is an animal that is specifically trained to do a specific task, and under federal law, that can be a dog or a miniature horse.
That's it.
And they are certified. They are specifically certified. Obviously, the traditional thing we think of is a seeing eye dog. That's a classic example of an assistive animal. Those really aren't where we're the tenants are confusing the concept. They use the wrong terminology, but guess what? You're not judged on the terminology they use. You're judged on what they're asking for, okay? Even if they're using the wrong words. A comfort or companion animal is basically any animal that any qualified person, and the definition in the draft regulations is so broad, I'll come back to that, says that that person needs the animal for support, for emotional well-being, for their anxiety reduction. And the qualifications you don't have to get that from a psychologist. Anybody in the medical field, a social worker, a registered nurse, all can give you that letter. And once you have that letter, there is nothing you, the landlord, can do to contest that specific need. Okay? And by the way, it doesn't have to be a dog. The law does not state, federally or state, that it has to be a dog, a cat,
pig.
how about an iguana, a monkey. The law gives us zero guidance. And 3 years ago, I begged the state council to please consult the psychiatric profession on what are the commonly approved animals in their profession. Of course, we all know what the answer is going to be. It's going to be dogs. And then we can get rid of reptiles and fish, or monkeys that could tear people's faces off, whatever. But unfortunately, it looks like the regulations that are going to be adopted, and I Vegas odds, I'd say it's like 99% going to happen. The new regulations are going to say not only that anybody can, that a comfort animal doesn't have to be by a doctor, but it's gone down to the member of a peer group. The member of a peer group. So if I'm in a 12-step program, and one of my buddies in the peer group says, I'm with Kelly in AA, and one of the important things of sobriety is to have his support raccoon, that would qualify under the Fair Housing Regulations. Slam dunk, okay? Oh, no, there's one more. In the proposed regulations, and I don't think it's the law right now, I could be wrong, the proposed regulations also say that it doesn't have to be a peer group support member, but it could be somebody who's known that person for long enough to confirm the disability exists. So in other words, your next door neighbor who says Fido or Fluffy or whoever calms Kelly down, that is going to be enough. So the bottom line, folks, is in your rental housing, the threshold is so low for comfort animals, okay, that's why you're seeing them on every plane flight that you take these days, in restaurants, in stores. Those are all not assistive animals. They're comfort or companion animals. Now, any problems that they cause, you can handle, because now that accommodations become an unreasonable accommodations. If they make a mess on the floor, they menace people, they bark, the comfort rattlesnake bites somebody. Okay, now it's an unreasonable accommodation. All right, so you aren't powerless. But what you cannot do, and this is under current law, even before the regulations, you cannot say, okay, so Kelly, you have a comfort dog. We're going to have a $200 extra deposit because we know we're going to have an extra carpet cleaning involved. That is a dead bang violation. Just wait for the lawsuit. Okay? You have to wait for the problem to happen and then respond to it. You can't deal with the problem in advance, even though we all know it's going to happen.
What happens if your nanny shows up with a comfort animal at your house to work?
Stop it. That's my husband, so stop it. I can tell you that CAR's position on this is that they were not going to get involved in it because they were hoping that Fair Housing would deal with it, and they were hoping that it would be a California medical doctor requirement.
No way.
And that's not where they're going, so CAR will probably take this up again. But that is what they were trying to push through because they wanted it to be a fair housing regulation as opposed to the legislature.
I can guarantee you we will be unsuccessful in that. If you simply look at the background of the Fair Employment and Housing Council, they are good people, committed people, but in recent years the membership is skewed primarily towards employment lawyers. The chair, Chaya Mandelbaum, is a wonderful man, brilliant. He's an employment lawyer. So they are relying on Dara Schnurr, who is a disability rights advocate, and a law professor whose name just escaped me from a Bay Area law school. They don't have anybody on the council that has any connection to real property. So we are going to lose this fight, and it is going to become more a wide open field. We're just going to have to get used to comfort animals is the bottom line.
Yes, ma'am.
Me? Yes. Okay. My question is going back to, the sexual harassment. I have 2 people in my building that have a love connection. Okay, so they're dating. So one of them I'm gonna ask to move soon. Can they come back and say that they were sexually harassed?
A consensual relationship between tenants. Okay, right now it's consensual. Here's the problem: when that relationship ends, guess what's going to happen? What? They chased me for years. Make them go away. Yeah, that's the kind of conundrum that we're all going to be placed in now that the law already says we have to prevent these unwanted advances. It's not. What are we going to have people do? Sign an acknowledgement that this is a consensual relationship? It sounds nutty.
I was forced with undue influence to have to sign.
Yeah. I didn't want to go out with them, but they lived across the hall. I had to. I had no choice.
Okay, my question is regarding evictions of a squatter. It's a family, and the owner lived out of state. They've decided to sell, came back and found a family living there. It's still boarded up, it looks abandoned, but they're in there, and they won't move. Do you have to go through the whole process of eviction?
Got to give them notice. Yeah, if they've been there for less than a year, I'd give them 30 days notice. Then they're not going to leave. You file an eviction to get them out. It's unfortunate.
Okay, last one.
Yeah, as far as rent control, I know that there's been like Long Beach who's had petitions. What do we know about it coming to other cities? Is there anything being signed by either landlords or by realtors, commercial realtors, that can help so we can support?
I can tell you that Long Beach is putting it on their ballot in November. And if you think about who lives in Long Beach, it's not the landlords, right? It's the tenants that live there. So the chances of it passing are probably going to be pretty high. I have not looked at the proposal itself, so I don't know what the applicability will be, but my guess is that it will look somewhat similar to LA just because of the proximity. There's a lot of cities up in Northern California that have been passing it over the last couple of years. And, as disappointed as we are, I think rent control is here to stay. It's not probably something you need to be concerned about in a Torrance or Redondo Beach or Manhattan Beach, but, because you have more home ownership, owner occupancy there. But when you're talking about locations where the owner occupancy rate is super low, you're going to have a higher chance of rent control. And I think that because of the affordability of California, particularly the areas that we represent clients in, I think that there's a real problem for tenants to try to figure out, how do I pay my rent on a $50,000, annual salary? And so rent control seems to them to be the right choice. But if you drive through LA and you look at the older buildings, they're becoming dilapidated. They're, barely meeting the standards of habitability because nobody wants to put money into a rent control building.
So is there anything that we know that we can help as far as help our owners that you guys know of?
The unfortunate part is owners don't get to vote where their properties are. They only get to vote where their home is. So the only thing they can do is just maintain active status in the council meetings and stuff of the locations where they live. CAR is not getting involved in that stuff, to my knowledge. They just, I think they feel like that's a bad decision for them to say one way or the other.
Okay.
They tried to get it statewide, and that didn't pass.
This question is about property. Two owners with back-to-back properties have a tree on right up at the fence line, and the roots are huge, encroaching on the adjacent property, and and likely about to damage the foundation. What does the damaged property owner, what is his right?
Do you want to talk about that?
I would say, generally speaking, right, you can protect your property if it ends over on your side, but what the neighbor is going to argue, if you're cutting up those roots, then you're also damaging his tree, right, their tree. So those are those things lawyers love to get in the middle of. That you're allowed to protect your property. What I would say is trying to work out some sort of agreement with them. Legally, if it becomes a fight, it cuts both ways.
There's law in California dating back to the 1880s that says the owner of a tree is the land on which the trunk rests, okay? And it also says that the owner of that tree is responsible for damage the branches or roots cause. So there's no negligence need be shown. But a lot of people mistake. I went through this with my neighbor. I have a magnolia tree that's like 70 years old, 80 years old. It is massive. And it has roots that we dug some up. They're like trees themselves. Well, a supervising attorney in the California Attorney General's office moved in next door and said, "Kelly, my garage my floor is heaving up because of your tree." Now, I had to fight with my own insurance company saying, okay, I've published articles on tree liability. I'm losing this one. You need to pay and not wait for a lawsuit. The only limitation on chopping off branches or roots is there is a published appellate case that says that while you can chop off roots and branches overhanging your property, you can't do it if it would damage the tree. So there's where I absolutely agree with Blake. You've got to work together, and because if you're going to kill the tree, then obviously there's some solution. So what we did was we had an arborist study which of the massive roots we could chop, and it turned out we could. A fair number of them. And then I remodeled my backyard, so now I have a deck that's about 18 inches high over the roots, and it actually looks pretty okay. And my neighbor never sued me.
All right, Kelly, you had one additional comment before we close.
How many of you are planning on buying or selling an apartment building in 2022 or 2023? Anybody? Okay, that's going to be a real interesting time period for all of us because there's a bill called SB 721. You need to know about if you haven't already heard about this. This is one of those classic bills that sprung out of a tragedy. You may remember from news reports several years ago about a balcony in Berkeley that fell but killed a bunch of young people. Okay? All right. Well, talk about news creating bad law or potentially bad law. SB 721 is requiring that housing providers and HOAs that have balconies have an engineer inspect those balconies once every 6 years. And it doesn't really say whether it's a destructive inspection or just a visual inspection. I think they mean visual. But those of us who deal with construction issues know that you can't tell a lot about the balcony's health without tearing it up a little bit and looking at the joist and seeing if there's dry rot hidden underneath the deck. Anyways, long story short, this bill's current version, they did liberalize it a little bit. Originally, they gave HOAs 6 years, and I think they gave commercial owners 4. Now, everybody gets 6 years. So by 2024, all commercial properties, residential commercial, that have balconies have to have been inspected by an engineer, and then every 6 years after that. That bill has already passed the Senate. It's now in the Assembly. So this thing has legs. The vote was pretty lopsided. I checked it yesterday. It was like, I don't know, it was, there were only like 3 or 4 no votes. So I think it's coming, and it'll become law next year, almost certainly, unless somehow we get enough people to say, are you kidding? Because the economic impact, yes, we want safety, but the economic impact of just mandating a 6-year inspection, and then, by the way, what happens if we don't find engineers who are willing to take on the risk of doing these inspections, because they're taking on a huge liability for this. The cost, even if we can find somebody to do this, is going to be massive. I just want to alert you, SB 721, if ever there was a good time to talk to your Assembly representative about this bill on behalf of your clients, this would be a very, very good time to do so, because it's early in the Assembly committee process, and again, it's already passed the Senate. So unless we really mount a massive effort, it's going to really change our commercial and our HOA properties.
Thank you. Thank you guys all for coming. Thank you, Holly, Blake, and Kelly, for your time. We appreciate it.